Good morning. Are you Jeremiah Branch?
Yes, ma'am.
Good. And Mr. Branch was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1382 and 1385. And I received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir. Yes, sir.
Any additions or corrections?
No, I think so.
All right, Mr. Branch, I am going to find that you entered your plea of guilty in each case freely and voluntarily. In cause number 25 DCCR 1382, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine in that case and to follow all of the rules and conditions. And I'm going to go over some specific ones in just a minute. And then in cause number 25 DCCR 1385, also find sufficient evidence to find you guilty, but follow the agreement that you made and defer all proceedings and place you on probation for 10 years. You will also be ordered to pay a $500 fine in that case and to follow all of the rules and conditions of probation. A couple of specific things that you're going to be required to do. One is to enter and successfully complete the JCDI program. That's an outpatient intensive program for drug treatment. So it's to be able to give you the tools to stop using whatever drugs you're using, stay clean so that you can be successful in your probation. Also, I know you've already gone and I think have some relationship with Spinal Tap, and you're going to be required to continue all of that. That's part of your probation. Obviously, that's something that you need to make sure you also can be successful, okay? If you do everything you're supposed to and successfully complete these probations, this is an excellent opportunity today because you do not have these felony convictions on your record. And at the end of the probation period, if you're successful, the cases will actually be dismissed and you'll never have convictions on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty in each case, and you could be sent to prison for anywhere between 2 years and up to 20 years. Do you understand? All right, in each of your cases, I'm handing you the trial court certifications. That shows that these were agreements that I followed, and so you have waived your right to appeal. I will sign dismissals in cause numbers 25 DCCR 1383 and 1384 as part of that plea agreement as well. All right, good luck to you, sir. You can go back with the bailiff. And are you Ruth Stewart?
Yes, ma'am.
This is cause number 25 DCCR 1692. I'm going to take judicial notice of the court's file. It includes an evaluation that was prepared and done by Dr. Hamza regarding competency to stand trial. That report is dated December 16th of 2025. And the finding in that report is that Ms. Stewart is not competent to stand trial. Is there any other evidence with regard to competency?
None from the defense, sir. No.
All right, then based on that report, I am going to find Ms. Stewart not competent to stand trial, order that inpatient treatment is required for competency restoration, order that she be sent to the appropriate facility for a period of not to exceed 120 days from the day she gets there for competency restoration, and then we will await a report from whatever facility that is. All right, you can go back with the bailiff.
Now, a month.
Yeah. Day, and what is the announcement?
Your Honor, the state is ready for trial, although there's a witness that I really do need to put on our case and is unavailable for trial. So,
Well, you can't be ready and need a witness too. So either you're ready or not,
we need that witness, Your Honor.
okay?
It's the lab animal, DNA lab animal.
Okay, and she'll be out all week?
What she told me was she was unavailable to travel and testify this coming week.
Mr. Matuska?
Your Honor, I spoke about this already with Mr. Nichols, I understand.
Okay,
And whatever scheduling that needs to be done, I can accommodate the court.
okay. Obviously, since Mr. Carino's in custody, I want to try to get it tried as quickly as possible. I'll reset it off of this trial docket to the next available trial docket. If there's any change, and that's obviously before any change that's going to take place, just let me know and we'll get somebody that can jump in as quickly as possible. Mr. Carino, I'll get your case set as quickly as possible, but I'm gonna give the state one recess so that they can try to get that witness, okay? All right, you can go back with the bailiff.
Thank you.
Yes, sir. And Mr. Victoria is charged with murder in each of cause numbers 21-36410 and 21-36411. And what is the announcement?
Your Honor, I plan to file a motion for trial this week on this. There's quite a bit of evidence. I've talked to Mr. Smith. I'm going to provide that to whoever's needed. But first, I need to file a motion.
Okay, so Mr. Victoria, Mr. Matuska is going in a different direction, and so he's going to have to file and get off of most of his cases over here. So what I'll do is we will have somebody prepared this week to appoint as soon as he gets that filed, that can get kind of caught up. I know there's a lot of discovery. Mr. Matuska is going to get that to the court. We'll get that to whoever we appoint, and they'll begin preparation real quick and be out to see you within a week or so. Okay, you can go back with the bailiff. Mr. Coleman, yep. Good morning. You're Jacoby and Dorsey. And Mr. Dorsey, in cause number 25 DCCR 1896, you're charged with a second-degree felony offense of manslaughter from November 17th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in the institutional division of the Texas Department of Corrections.
Your Honor, it's my understanding he has a prior felony conviction that's enhanced to a first.
That is the way, well, it's not indicted that way, Judge, but I will be seeking a repeat offender. I'll be filing a repeat offender notice.
I wrote first degree on there.
Right.
Because, and there's some confusion. He also explains that his underlying conviction is on appeal, I believe. That's what he tells me. So I told him I would check with the court to make sure that's right. If it's 5 to 99 or 2 to 20, because I didn't know the status of all the other stuff.
If it's on appeal, then potentially that could be an issue with regard to it being a final conviction. So what can happen is if that appeal, once it's complete, and if they affirm that verdict and that conviction, and at that point, this would then potentially become, for punishment purposes, enhanced to a first-degree felony if that conviction becomes final. And I don't really know, the final conviction date, if that creates an issue because of the appellate process.
I'm not sure, Judge. I'm gonna have to look at it.
Judge, and I don't know the answer to that question.
Yeah.
But being familiar with this defendant, I tried him next door involving several co-defendants. Ms. Duchamp and I did several years ago.
Okay,
He actually was on probation over there for cooperating with us for aggravated robbery involving an adjacent murder. He received 30 years on that revocation. I went back and double-checked, and I'm sorry to interject, double-checked that date. That hearing and that revocation was before this offense date. He had actually gone to Jefferson County Jail and was waiting on his 30-year sentence at TDC when this offense occurred in the jail.
And with that being said, Judge, the state will also be seeking, to the extent the law will allow us, to stack any sentence in this case on top of that 30-year sentence.
He's
But-
already filed the paper for that.
that 30-year sentence, though, is the one that is on appeal.
Possibly on appeal.
Okay, so I guess
So
that's
I
the
think
question.
Our position would be that the decision that was made that was then subsequently
It would go back to the
affirmed would go
conviction
back to
date.
that date, yes.
That would tend to be what I would think, but we would obviously have to do a little bit of research to double check. And so I think that the most thorough way to do this is for you to understand that if that conviction is affirmed by the Court of Appeals, then it would appear that the conviction date then goes back to when that original conviction was, which was prior to the date of this offense. And therefore, it could enhance your punishment to that first-degree felony. If you go to a jury and they find that you're guilty and they find that conviction true, which means your minimum punishment would be 5 years instead of 2, up to 99 years or life in prison. Do you understand? In addition, if it's affirmed prior to any trial date or anything like that, and you're found guilty, Mr. Coleman can ask that any sentence that a jury gives you be stacked on top of or run consecutive to that 30-year sentence.
He's already filed that paperwork, Judge.
Okay, and that decision would be up to the court or up to me. So if you're found guilty, that could be a potential punishment in addition to yours, is that whatever the jury gives you, I could stack on top of that 30-year sentence. Do you understand all of that? I'm sorry, speak up. And I have a plea bargain rejection that you've signed here with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go on just the count of manslaughter itself for a 20-year term in the institutional division. And that would be to run concurrently, that would be stacked.
That would be stacked, Judge. At least that's the offer as it stands. The state will entertain a counteroffer.
Well, I mean, that's,
I
okay.
get it, Judge.
I can't, don't know why anybody would
No, I
accept
get
that offer. So, do y'all want to visit a little bit more about this?
I can
and
talk to him
before I
and see
put
if-
it on a trial
I
docket?
can talk to him about.
Let me hold it.
possibilities.
Y'all visit a little bit about that before I take this
Okay.
to the trial docket. You're Jacoby and Dorsey. All right, and was there any additional negotiations?
Just for the record, Judge, I've asked him without talking to Mr. Coleman if he would take the 20 years if it wasn't stacked. He indicated that he wouldn't. Mr. Coleman kind of, it implied that he may offer that, so I didn't know if you want to change that, but it hasn't really been an offer of that, but.
All right, so Mr. Dorsey, it sounds like even if it was a sentence that would run concurrently at the same time as that 30-year sentence that you're serving now, or could be serving if the appeal is affirmed, that you don't want to take any offer or a plea on this case. Is that correct? All right, then what I'll do is get your case set for trial. Mr. Dorsey, Mr. Parker has been appointed to you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, we'll get that done. Mr. Parker, you're released, and Mr. Dorsey, someone will be appointed today. They should be out to see you very soon to begin preparation for trial. And do y'all know how long the appeal has been pending? Does anyone, do y'all have any idea?
It's been a couple months at least.
Okay. It was out of the other court though, right?
Yes, ma'am.
Okay. All right. So if y'all get any information on that, if you'll just let me know, it'd be nice to have that potentially by the time we go to trial, but we'll see. All right. Thank you, sir. You can go back with the bailiff.
And I think that Rep Rice hired on that David Greer.